Well, good morning. I'm Jagendra Kumar. Topic for the discussion today is warranties in insurance. Warranties in insurance. A breach of warranty within an insurance contract, no matter how immaterial to the insured risk, operates automatically to discharge the insurer from all liabilities under that contract as from the date of breach. So the effect of this is expanded by the existence of basis clauses which operate so as to churn certain pre-contractual representations made by the insured into warranties. Modernizing the Insurance Act is urgently needed in India to suit the changing business dynamics. Insurance Act 2015 UK initiated many changes that suit the requirements of customers and business entities. Here we have to understand the implication of warranties and its evolution over the period. It is pertinent to mention the two insurance laws that work in the UK, means in England, are the Consumer Insurance, that is Disclosure and Representation Act 2012, that deals with the consumer insurance contracts where an individual enters into the contract holder mainly for purpose unrelated to the individual's trade, business or profession. So the word consumer means an individual entering a consumer insurance contract to proposing to do so. Then the Insurance Act 2015 applies to non-consumer insurance. It defines a non-consumer insurance contract as a contract of insurance that is not a consumer insurance contract. So the changes made in these two acts and the Marine Act 1906 somehow were not incorporated in India's Insurance Laws Amendment Act 2015. See, Section 33(1) of the Marine Insurance Act 1906 states that a warranty means a promissory warranty, that is to say, a warranty by which the assured undertakes that some particular things shall or shall not be done, or that some conditions shall be fulfilled, or whereby he affirms some negatives the existence of a particular state of fact. Section 33(2) states that a warranty may be express or implied. Section 33 states a warranty is a condition which must be exactly complied with, whether it be material to the risk or not. If it is not complied with, then subject to any express provisions in the policy, the insurer is discharged from liabilities as from the date of the breach of warranty, but without prejudice to any liability incurred by him before that date. And then Section 34(2) provides that once a warranty has been broken, the insured cannot use the defense that the breach has been remedied. No compliance with the warranty, however, is exempted only in three cases. One, when the changed circumstances made the warranty inapplicable to the circumstances of the contract, or when compliance with the warranty is rendered unlawful by any change of subsequent laws. Secondly, where a warranty is broken, the assured cannot avail himself of the defense that the breach has been remedied and the warranty complied with before loss. And third, the insurer may waive a breach of warranty. Now, the Marine Insurance Act 1906 did not allow for any remedy of a breach which changed for the better with the enactment of the Insurance Act 215 UK. So it must be noted that conditions and warranties are contract terms based on the importance of the terms in question and the subsequent consequences if they are breached. In most contracts, the warranty impacts only some relatively minor aspects of the agreement. So the affected or wrong party has a right to claim damages, but no right to terminate the contract altogether. On the other hand, a condition impacts essential aspects of the agreement as it travels to the root. So the wronged party can both claim damages and terminate the policy as well. In insurance contracts, the distinction between condition and warranty is somewhat blurred, and all warranties are treated as a major part of the contract. Insurance contracts don't have the same meaning as the general contract law. In insurance law, the term warranty is given a different meaning and refers to a major contract term. So before the Insurance Act 2015 IEA 2015 UK, warranties were the most critical terms in insurance contract with severe effects if broken. However, the introduction of IEA 2015 gave respite to policyholders as it mitigates some of the drastic impacts of the breach of an insurance warranty. A breach of a warranty in an insurance contract was used to terminate the risk before enactment of this act. So, in this respect, a warranty was similar in effect to a condition in the general contract law. In India, a pre-contractual statement, like a statement made at the end of the proposal form, is converted into a warranty using the basis of contract language. So, any inexactness discharges the insurer from the liability of the law, liability for loss. That has been abolished, the basis of contract clauses. A representation cannot be converted into a warranty using any provision in the consumer insurance contract. But converting the statement made by the insured into a warranty is not permitted. In this respect, it is not possible to contract out of the IEA 2015. So the basis of contract clauses is forbidden for consumer insurance. For consumer and non-consumer insurance, a breach of the warranty suspends an insurer's liability only where the breach is rectified before the loss. The insurer must pay the claim. For terms not relevant to the actual loss, an interesting twist to the warranty. In the case of a warranty or other term intended to reduce the risk of a loss of a particular kind in a specific location or at a certain time, the insurer will not be able to rely on a breach of the term if the non-compliance could not have increased the risk of the loss that in reality occurred. So the interaction between the section 10 breach of warranty and section 11 terms not relevant to loss explains that a breach of warranty suspends an insurance policy and the insurers will not be liable for any claims until the breach is remedied by the insured. Is remedied by the insured. So warranty as such See, in marine insurance, warranty, marine insurance is a contract wherein the insurer, that is insurance company, undertakes to compensate the policyholder for any damage to the insured property due to the covered causes. However, in such contracts, it is essential to ensure the protection of the parties so that none of them suffer unnecessary losses. So for this reason, the insurance agreement consists of certain clauses that ensures fair play between the insurer and the insured. But the principle of warranty in insurance is one such clause that is a part of most insurance contracts. Now, both the parties to the insurance contract must be aware of this clause to know the rights and responsibilities. In simple terms, the principle of warranty is an assurance by the insured to disclose all the relevant information about the subject matter of the policy to the insured. So the insured promises to reveal all the true and correct information to the insurer, failing which he may be unable to receive part of the complete benefit from the policy. Under the warranty principle, the insurer promises to adhere to certain conditions and reveal certain truthful facts. This principle helps the insurer to ascertain the extent of the risk and calculate the premium to be charged from the insured. Thus, the insurer will be saved from unnecessary risk and from including financial losses. Similarly, the insured can rest assured that if he fulfills all the warranties and requirements, the insurer is obliged to compensate him in case any unfortunate event damages the insured property. The insurer must disclose the correct and accurate terms and conditions of the insurance contract to the policyholder. The insurer must reveal any changes in the premium amount, extent of coverage, etc. to the insured. And the insurance company must carry out the investigations and claim settlement in a fair manner. Now, warranties plays a crucial role in the administration of marine insurance policies. Both the parties to the insurance contracts are largely bound to the promises as they outline the conditions to be met. The importance of warranties can be understood from certain points. Say, for example, it governs the insurance agreement. Warranties lay down the legal ground for governing the insurance contract. They clearly establish the terms which must be agreed upon by the insured and the insurer. Therefore, both parties become aware of their rights and obligations, which leads to a smooth fulfillment of the contract. Then adherence to the warranties is essential for the claim settlement process to take place smoothly. When both parties fulfill their contractual obligations, there are no disputes or claim denials. So express warranties explicitly mention the obligation and expectations of the insured. Therefore, there is clarity to the insured that a breach of contract from his end may deny him the insurance claim. Similarly, the insurer knows the exact amount of risk involved, enabling him to fix the premiums accordingly, so he does not incur a loss in the contract. Warranties require the insured to adhere to the legal requirement of the maritime industry at the national and international levels. Following the laws and regulations ensures the safety of lives, property, and the maritime environment. There are two types of warranties in a marine insurance policy which must be fulfilled and adhered to by the insured. If the insured fails to uphold the warranties, the insurer will be discharged from paying the part or complete claim amount. First are express warranties. Express warranties are promises and assurances made by the policyholder that are expressed and explicitly stated in the insurance policy document. These are the warranties which are clear and leave no scope of any confusion. Then promissory warranties. Promissory warranties are assurances stating that few conditions will be met during the terms of the policy in case the insured fails to keep the said promises or conducts any breach. Then affirmative warranties. Affirmative warranties are those statements or facts that are true at the time of policy issuance. Policyholders are well aware of these warranties as they are specified in the insurance. And there are certain implied warranties. Though implied warranties are not stated or explicitly mentioned, they are assumed promises. But they must be adhered to on the basis of the industry standards and practices, legal laws and basic understanding, though they are not present in the documentation. Every insurance contract has an implied warranty that the insured and his vessels will engage in legal activities like that. So the important question is now remains to answer is that it's heartening to note that the regulator in India recently formed a high power panel to suggest measures for insurance reforms. It is expected to examine various areas of the Insurance Act 1938 and recommend suitable and adequate amendments in keeping with the changing business trends and requirements of the customers. So now the time has come to work on it, because warranties may be applied in marine insurance only. For example, Section 39 of the Marine Insurance Act 1906 automatically carries implied warranties of seaworthiness into every marine insurance policy. In non-marine insurance, warranties must be expressly worded in the contract. The time has come to modernize the Indian Insurance Act to make it customer friendly. Thank you. Thank you very much.